All right, good afternoon, everybody. My name is Andrea Chin. I'm a judge here in Seattle Municipal Court. I'm here today in my role as the probation liaison judge, and I'm also part of the Probation Evolution Project Steering Committee. My co-presenters today are two of our probation department managers, Carol Bell and Jason Grant. This is our third webinar this year, and if you attended the webinar in June, you heard an overview of the Probation Evolution Project. And during this session, we are going to review a little bit of that overview information, and then we'll get into the details of some new probation policies that are going into effect in January 2023. And we will save the last half hour for audience questions. The Probation Evolution team has based its work on what we've learned from multiple assessments and evaluations, as well as feedback from stakeholders and probation clients. I'm glad to be part of this exciting project. Why probation evolution? Well, in 2020, we began redesigning our approach to probation as a result of stakeholder and community feedback and our desire to eliminate disproportionate impacts on people we serve. Over the past several months, we've hired a project manager, and we're ensuring that there is a clear, unified vision for the project backed by the shared commitment of the judges. Our team has developed the following goal statement for this project: transform our programs and services division by stepping away from traditional incarcerative reactionary approaches to misdemeanor supervision toward one that is hopeful, equitable, and supportive of client success and growth. We've learned a lot so far over the past years, and we want to continue learning as we bring more community engagement into this work. Our goal is better outcomes for those referred to probation and for the community as well. All right, so how do people get to probation? Probation is a post-adjudication case management program. What this means is that probation may become involved after a defendant pleads guilty, is found guilty at trial, or resolves his or her case with something like an agreed continuance with conditions attached. When a case is resolved, the court may order several conditions that will require some action and engagement on the part of the defendant. Sometimes conditions are negotiated and agreed upon by the parties, and sometimes the court will impose them on its own. Many cases in Seattle Municipal Court are never referred to probation. However, after reviewing the facts and circumstances of a case, the court may determine that certain conditions of sentence or resolution would be appropriate. Some common examples are chemical dependency or mental health treatment. In those cases, the court may refer that defendant to probation to monitor those conditions. Probation referrals are typically reserved for high-risk cases, such as DUIs and domestic violence cases. All right, so this slide has a list of the most common conditions imposed. The court has discretion whether or not to order any of these conditions. Probation staff rarely, if ever, weigh in on what conditions are appropriate on any case. Instead, the probation counselor's role is to support their clients to successfully complete the court-ordered conditions. They help their clients achieve self-identified goals with the ultimate objective of transitioning them out of the criminal legal system. Now, today, we're going to discuss an update to our policy on how probation responds when a client is not in compliance with their conditions.
Thank you, Judge Chin. In the next few slides, we're going to review our updated non-compliance policy, which we expect to implement in January. It's important for us to share with you how probation counselors will engage the clients that are having challenges with compliance. This is not a presentation that's focused on the judicial response, but how we, the probation department, work with them prior and what information the judge will receive. If you may recall from our prior presentation, the judges will have the added benefit of a quarterly progress report that is shared with them, and it talks about what the clients have been working on during their term of probation. The goal of this policy is to provide a framework for probation counselors to address non-compliance in a consistent, supportive, and transparent way. Our objectives are to define the differences between technical and substantive violations and provide guidance for responding to each type. This policy will give guidance for situations when brief interventions are enough to get clients back on track during temporary struggles. The policy will also give guidance for situations when there's more structured, supportive case management that is needed. This will help to address repeated non-compliance, chronic substance abuse, and continued offensive behavior. As you can kind of see here on this slide, it's a little bit of a continuum. We start with the receiving of feedback and then analyzing the problem. This work started with the court listening to community members involved in the legal system about their thoughts on noncompliance with misdemeanor probation. Community members were asked to share their thoughts on what were appropriate responses to technical and substantive violations. How can we eliminate bias? What types of responses to violations are equitable and effective? All of that was a part of the conversation. The court leveraged this information that we learned from community members. We also looked at information that was gathered from previous audits, and we utilized our staff to help develop and update this policy. As I said before, it starts with receiving feedback, analyzing the problem, exploring solutions. We design a solution, test what the solution design is, implement the solution, and then measure the results. Now I'm going to turn it over to Jason to get into the details.
Thank you, Carol. The reimagined policy creates a decision-making framework that wasn't available to counselors before. It identifies 3 levels of noncompliance and the response protocols for each level. Those protocols are responsive to escalating levels of noncompliance with really a focus on enhanced case management in hopes of resolving issues without having to involve the court or scheduling court hearings whenever possible. As you can see from the slide, level 1 noncompliance is what we consider technical noncompliance, not abstinence related. Violations include not reporting to probation, not attending treatment sessions, not following through with court-ordered programming. With the first incident, policy will allow probation counselors to address the noncompliance directly with the client and collaborate on a plan moving forward. With the first incident, if noncompliance continues, the probation counselor will then initiate what we call a case intervention plan. So if that initial conversation with the client, it doesn't prove to be effective in supporting the client to regain compliance with either reporting or treatment or programming, then the counselor then addresses the behavior in what we call a CPI or case intervention plan. This is a counselor-focused plan that increases contact with the client and the treatment provider in hopes of collaborating and coming to a plan to support the client in regaining compliance. CPIs are typically 60 days in duration and allow for a certain amount of time for the client to identify the barriers, the counselor to support them to come back into compliance with in hopes of avoiding a hearing. If non-compliance continues in spite of a CPI, the probation counselor then requests a hearing for the court, and the counselor would maintain that same level of support and client connection until the hearing takes place. The second level of technical violations are abstinence related. Violations in an abstinence related technical violation typically would include a positive or missed drug test. With the first incident, again, the counselor submits, it connects with the client directly, connects with the treatment provider, collaborates on a plan to address the drug or alcohol use. The counselor does submit an abstain violation report, but does not request that the court schedule a hearing. The scheduling of a hearing will always be a decision that's left to the judge based on the information that's provided in that violation report. With the second violation, an abstain violation within 120 days, probation counselor again submits an abstain violation to the report, initiates a case plan intervention or CPI to address the client's barriers, increases contact with both the client and their treatment provider. The intervention should not last longer than 60 days. A hearing is not recommended unless there is a clear community safety, client safety, or victim safety concern. If, in spite of the CPI, the enhanced case management, the increased contact and collaboration with treatment and the client, drug and alcohol use continues, probation counselor submits an abstain violation report and requests a hearing. The counselor again maintains the same level of support and client and provider connection until the hearing takes place and the court addresses the violation. Last level of violations, what we call substantive noncompliance. Violations include new criminal law violations, alcohol-related ignition interlock device violations, substantiated victim contact, or extended technical noncompliance. The probation counselor, when they become aware of these violations, requests a status report and requests a hearing. If a case plan intervention is in place already, the probation counselor maintains that level of support and connection that's identified in that plan until the court addresses the violation. The counselor's status report to the court or review report to the court will include a summary of the CPI, the case plan intervention, and a recommendation from the probation on whether the client is appropriate for continued or ongoing supervision. Recommendations to maintain probation will detail any monitoring or treatment plan adjustments that can be made moving forward. Recommendations for discontinuing probation will continue to involve shared decision-making with probation managers prior to review report submission. Review reports will not include recommendations related to revocation. The reports will no longer include to add any mandatory conditions for the client unless there's a clear intervention that's in the best interest of the client's therapeutic health. Decisions to revoke or close probations will continue to, or to add sanctions will continue to be deferred to the court, the city attorney, and defense counsel. Focus of the probation counselor in this space is to advise the court on whether ongoing supervision or monitoring is appropriate and outline a plan moving forward. So again, the plan, we have some work to do between now and the end of the year. But the plan right now is to expect to make these changes and go live in January of 2023. And we have a lot of time to take any questions or thoughts you have at this point.
I am going to go back to the slide that shows the different levels because a lot of information. And if anyone in the audience needs to see a particular slide again, please feel free to put those questions in the chat.
Laura, Siobhan is indicating that her chat says disabled. I don't think we have, I'm not sure if that goes across the board with other participants.
Yes, sorry, the when I said chat, I meant Q&A feature. Participants aren't able to use the chat. And I do see a question, will this slideshow be emailed out? Yes, we will send a follow-up email with these slides, and they'll also be posted on our website and on our blog.
I think this means that we were really good and really thorough in our information, and they just are waiting in anticipation for what comes next in January.
So actually, I have a question for one of the probation folks. Maybe you can talk about how the new policy that's going to be implemented in January, how you see that as, I mean, how that compares to what you were doing before, and what are the benefits of this? Do you see any downsides? So just from your perspective, maybe you could talk about that a little bit, either Jason or Carol.
I can get us started, Judge. Thanks for that question. I think what this policy really does is put structure around, what's expected of probation counselors when their clients have encountered noncompliance. That our policy, our violations policy, which has been around since the late 90s, has always allowed some grace period for clients that are in what we now call technical noncompliance, but it was really limited to things like attendance at appointments and things like that. We've put a little more structure around, what goes on during that time when we're working with clients to try to avoid a hearing, and gives the counselor a lot more opportunity to really ramp up their case management and their supportive footprint with a particular client, in hopes of not having to bring a case before the judge. We have a lot of goals with this policy. One is to keep clients out of court and to avoid the possibility of incarceration, especially in the technical violation space. We really believe that when clients are in technical violation, if there's not a clear community safety concern, we can work with that client and build a team or a plan around them to give them the support and structure they need to get on track, and not create unnecessary hearings or put clients in an environment where reincarceration is on the table. So, what we really hope is, that in doing so, we have, and within that period of time, that grace period, we're really putting expectations on staff around, outlining what the plan is for that period of time. So you heard us talk a lot about CPI or case plan intervention. The probation counselor's ability in the misdemeanor level is pretty limited with respect to, what they can do with the client, but what they can do is have, more contact with them and being more involved in their life. and to have a stronger, more established connection with their treatment provider, especially when they're struggling with follow through with services. And so the CPI really basically says, look, the probation counselor is going to have conversations with the client more often. They're going to have conversations with the treatment provider more often. They're going to collaborate. There's going to be shared decision making around how to get the client through the period of non-compliance so that the hearing hopefully is avoided.
So Jason, can I ask you one more quick question? Because I see there's some other questions from people who are in the audience, but just how are probation clients apprised of the non-compliance policy? So in what way are they made aware of are they told about this up front, or does it kind of happen as things move along? So maybe you could talk about that a little bit.
Yeah, I think explaining what the process looks like is always a part of this work that we could do better at. And we recognize that when we were revamping our monitoring policies and how we determined the frequency or the method where clients were reporting, the classification, for lack of a better word. And so we really spent a lot of time in putting together processes that explained how a client phased through probation, how they went from in-person reporting to virtual reporting to no reporting at all. We need to give the same level of attention to non-compliance response as well. And so dedicating time to, create opportunities to explain the process with clients. At the same time, doing it in ways that is, easily received by them. So whether it's in a virtual or visual mechanism or just during the intake process. But really when that first indication of non-compliance is starting to emerge, having those conversations with the clients at that point about, look, this is what this process looks like if you're continuing to not report, or if you're continuing to struggle in services. This is the next step, and this is what ultimately how a client could find themselves back before the judge, and this is everything that we're going to do in support of you to try to help you avoid that. But ultimately, the responsibility is on the client to follow through, and we'll do the best we can to support them. But having those conversations is critical to them understanding what the road ahead looks like for them.
Okay,
Jason,
so Laura, I'm going to turn it back over to you. Oh, I'm sorry, Carol, go ahead.
No, I was going to read off a couple of the questions, and Jason, or even some of our probation counselors that are online may want to contribute to this. The first one was, I understand that the new system has specific guidance for how to deal with different types of violations. But besides this additional practice, are there key ways it differs from previous practice, i.e., new practices that are allowed or old practices that are prohibited?
I think the biggest thing that stands out in the new policy is the divestment from making recommendations for related to revocation and sanctioning. And so, by the time, if a case finds itself back before the court, reports from the probation counselor will be focused on whether ongoing monitoring or support for a client is appropriate, or whether based on the life of the case and what's transpired prior to that hearing, probation is recommending that probation be closed. Historically, and I think probably in a lot of other departments, probation counselors have been relied upon to make specific recommendations related to sanctioning, which includes jail time. And probation counselors at Seattle will no longer be taking on that responsibility. That responsibility will be left to the parties, city attorney's office, public defense, and the judge ultimately in making a decision on any sanction-related response. I will say that the new policy has an expectation that counselors work with their clients for longer periods of time before a hearing is necessary or mandated. and gives more structure and guidance around what that period of time looks like than the previous policy did.
Okay, and our next question we have is from Michelle. What sort of funded supportive services are available to individuals who have barriers to engaging in attending treatment, i.e. transportation, housing support, sober living options? I can say, and Jason, you're more than welcome to add on, what we do have available to our clients, we start out after the probation intake, always escorting each client to our courts resource center to avail them of any social services that they may need to support them during the life of their probation and beyond. This may include offering them bus tickets or signing them up for an ORCA card if they're eligible. We give them information that connects them to housing support depending on where they are in their housing. Sober living options include giving them access or information on things such as AA support, chemical dependency treatment, giving them information on how to get engaged with any funding support that may be available that connects them to treatment. For our DV program, we have the DVIP program. For some, not all clients, for those that have opted into that. We also have other resources that are available to the clients depending on, again, what they come in and report their needs are, or what we may identify some of their needs to be in our intake process or over the life of probation. Our next question we have is from Omar. It is, will the POs recommend additional conditions or leave that to the discretion to the judges?
I'll address this one, Carol. Our path forward is not going to include adding things to our client's plate when they're already struggling with what the court's imposed. And so largely, we're not going to be supportive of creating an environment that makes it more difficult for them to accomplish what we think is the most important component of their experience with the court, which is the entrance into and completion of treatment, which we know and recognize is usually evidence-based. So unless there is a clear therapeutic benefit to adjusting the treatment-related obligation of a client, it's not going to be our position that adding things to their plate is in their best interest. That being said, it's not our decision to make. And certainly there are other parties at the table when a case comes before the court. And those other parties might have different ideas or thoughts on the best path moving forward. And the judges will always take into consideration those thoughts and rule accordingly.
Thank you, Jason. The next question is from Cheryl. What have been the racially equity considerations taken into creation of this policy? So what have been the racial equity considerations taken in the creation of this policy? Cheryl, one of the things that we've implemented along the way is we've used the City of Seattle's Race and Equity Toolkit in the implementation of this process. In that, we've ensured to engage the process in a way that identifies where there's equity in the process, where we're engaging community and being thoughtful and making sure that all stakeholders have a voice in this process. We know there's a difference between equity and equality, and making sure that we are doing our best to provide those that come into probation with the supportive services they need so that they can be successful. If they're coming in at a disadvantage, then we want to make sure that we're giving them the leg up that they need. Again, part of this is really about taking an individualized approach when we're going through the intake process and identifying where everyone's barriers are to compliance.
I'll just quickly add to that. One of the things that's been critical to this entire probation evolution process is the understanding that we're accountable to the community and to report out on the outcomes and the impacts of our policies on the clients that we serve. And so we have made a commitment to share our outcomes periodically, once they're implemented, and how things like monitoring policy or the removal of a risk assessment tool or the creation of a new mechanism to determine, a client's monitoring level or phase level, or how we address noncompliance, how that impacts other populations. And so what you'll be seeing from us, in terms of these engagement type sessions isn't just to share what we're doing, but it's whether they're working or not, understanding that we might be coming back to you in 6, 9, or 12 months and saying, these are the results, these are the outcomes, and they aren't ideal. We will continue to be transparent in that as we evaluate their efficacy.
Thank you, Jason. I don't see any additional questions in our chat. Again, we're available to you all, the audience, for any questions you may have. We also welcome any follow-up questions as you kind of digest the material that's been given to you today. This webinar will continue to be available to those that were unable to view it on the court's website, as well as our previous webinars.
I did see that Ms. Haggerty, who is one of our probation counselors, this is going back to the question of whether probation would recommend additional conditions or leave that to the discretion of the court. And Jason had generally answered no. Ms. Haggerty does mention oftentimes the domestic violence unit probation officers will ask the court to impose recommendations from the DVIP assessment. So yes, that is correct. And I, as the full-time DV judge right now, the DVIP program is a little bit of its different from, I think, the rest of the programs we have, in that when individuals engage with DVIP, they're told from the beginning that they will be generally assessed for supportive services that could include things in addition to DV treatment. It could include mental health or chemical dependency treatment. So at the outset, those who are engaging in that program know that generally that conditions will be recommended by the multidisciplinary team. And so it's sometimes things that will become conditions are not known at the outset. So that's a little bit of a different, it's its own special program. Ms. Haggerty, was there anything else that you wanted to add? I've got her on chat, but I don't think she.
I'm here. No.
No.
Yeah,
Okay.
I kind of just want to make that kind of clear, just because DVIP is the umbrella, so to speak, and so
Yes,
it isn't necessarily going to be just DV treatment. So I think sometimes when a DVIP assessment is complete, the provider will identify that maybe CD or mental health was more the primary concern, and so that's not necessarily outlined with the court. And so sometimes we'll say non-compliance or compliance with DVIP, but we like to identify what it is we're specifically monitoring for the court based on the outcome of the assessment.
yes. Thank you for adding that, because that is a little bit different from the other probation types of monitoring. So DVIP is a little bit of its own program. Okay, so Carol, it looks like there's another question.
Okay. Yes, it is. What partnerships do you have with housing providers? We all know that getting into housing is hard and takes time and a lot of navigation. Besides providing a resource list, do you assist clients navigating the homelessness response system so they can successfully obtain housing, which will ultimately help them with compliance? Well, Cheryl, our probation counselors are limited in this area in terms of our housing resources, just like the rest of the community. It all depends on where the client is. We do rely on a navigator in our courts resource center to kind of help us along the way as we try to go through and match existing programs that are out there that may work for the client. We do a little bit of hand holding, but I cannot say that we completely help a person navigate the homelessness response system. We rely heavily on other social workers and again, our navigator that's in the courts resource center. But again, the resources they have available to them are pretty limited as well. What we do with what they're doing in the resource center is they are researching different programs that are available in the community and doing the best to match clients. Some of these resources, or what we found, a lot of them have to do with helping those along that are at risk of homelessness and maintaining their current housing or paying for the application process. Some of these programs are affiliated with the clients engaged in either return to work or full employment with the program.
And if Carol, if it's okay, I want to just reiterate, that our CRC in Seattle Municipal Court has staff that are trained and equipped to help clients start the process for accessing housing. The comment in that chat about besides providing a resource list, it's important that folks on this call and our partners understand that probation counselors walk their clients down to the CRC and connect them with those staff, because those are the folks that we have immediate access to that are most equipped to help a client access what we all know are limited housing options for so many of our clients that are in the city and even those that live outside of the city. So we are never stopping short or stopping at providing a list. We're not in the business of handing out paperwork and putting the onus on a client to do the heavy lifting. We have expectations that counselors walk their clients down to the CRC, especially when housing is of concern, but also when public benefits are concerned, transportation, phone resources, so that they can start the process for accessing or getting connected with those services. And it's the same services that those clients that are coming through community court are accessing when they're coming through that process as well.
I think let's give it another minute and see if any other questions come through.
If I could, I'd like to add one more thing if I can. I think one of the questions before asked about what's different. And I think that Jason, you guys did a really great job answering it, but coming from a actual caseload carrying PC, I think that who has, been working probation for 20 years, I think that implementation of what the case plan intervention is such a key component of what we're hoping to do moving forward. Having a client come to court is such a huge impact on their life, their time, resources, ability to have an attorney. And so if we're able to intervene at a time where traditionally we would set a hearing. So our policies were set up in a way that if somebody on probation is non-compliant for 2 consecutive months, we notify the court and request a hearing. This really gives us an opportunity to work with them a little longer and intervene with our expertise and their providers, their treatment, their community connection. And I think that's something that's so huge for our clients because I think people think that court isn't as intimidating as it really is for our clients. I think we get really accustomed to people going and it's normal for a lot of people, but it's not a comfortable experience or sometimes very traumatic experience for a lot of our clients. So utilizing this opportunity to really engage them, to avoid going to court in a sense of, being able to really kind of case manage a little bit more closely, I think really benefits our clients and something we haven't done before. So that's something for me, I think is so important moving forward, is giving us an opportunity to kind of really work with our clients when they actually hit non-compliance, because we traditionally go to the court rather than actually work with our clients. And we're still working with them, but the court intervenes at that moment, where this gives us an opportunity to use our expertise with case management to, get them engaged a little bit more so we can avoid having them go to court. And I'm really hoping that based on, our plan moving forward, we'll see a lot less non-compliant hearings for the individuals who referred to us. I just want to share that because I think that's a really key thing that we're hoping to be able to implement.
I appreciate that, Siobhan, from your perspective as a probation counselor. Benjamin, your question, do you know what percentage of people on probation are non-compliant? How many people are on probation in the Seattle area? So, we have different levels of intervention with clients across the Seattle Municipal Court. What we're talking about today is what we consider active probation. So clients that are referred post-adjudication by a judge after a disposition of some sort. And that number right now usually ranges in the 400 to 500 range. We do not track numbers related to how many clients are non-compliant, so I don't have that number for you. But in terms of total active, and we have a website that is updated periodically that shows current numbers. We're typically in the 400 to 500 range, but that does not include community court clients. That does not include pretrial services clients. It does not include clients that are being monitored for admission interlock compliance only. Just those that are on active supervision. Carol, do you want to tackle the question from Michelle?
Yeah, I was sending them out. I see on the CRC website, there is substance abuse disorder assistance referral section. Who should I contact to be added to that list as a place that clients can contact for services? Michelle, you are more than welcome to send your information to myself. You can send it to me or you can send it to Jason. I can give you my email address. It's carol.bell@seattle.gov. carol.bell@seattle.gov. Our next question is from Paige. Did probation counselors previously make recommendations for non-compliance? What is the benefit of shifting that authority?
I'll try to tackle that, Carol. Our policy has long been silent around what went into the recommendation section in our review reports. And so there's a lot of discretion with respect to what a probation counselor felt, given their experience and their relationship with the client, what was the best outcome post review process. That lack of structure is where inconsistent application, inconsistent impacts, and bias lives and cultivates. And so, as we wrapped our brain around, really what that, and I don't know if I'd consider it authority. I would characterize it better as a responsibility or role. But as we continued to reevaluate what that role was, we became more and more uncomfortable with being put in a position where, a specific recommendation on sanctioning was in the hands of a counselor that may or may not have a different viewpoint from another counselor. And so what we've decided to do is really shift our focus on, whether continued monitoring is the best course of action or not, and why. And that still provides a lot of opportunity for the counselor to outline in their reports all the things that have gone into supporting the client, all the approaches and the responses from those involved in the client that have gone into trying to support and assist the client in finishing their treatment related obligations, and then the client's responsivity to that. The reports also require that the counselor outline any community safety concerns that are evident. Is the client continuing to attempt to drive after consuming alcohol? Has the client completely absconded? Have they shown over a course of time that they're no longer interested in participating in services, reporting to probation, despite all of the efforts that those involved with that client have tried to do, and all the barriers we've tried to help them overcome. And so there's a lot of opportunity to sort of articulate, whether an ongoing relationship is appropriate. And if it's determined by a judge to not be, then we see it more as the role of the parties than ours to opine on what specific sanction, if any, should be imposed. And that's a commitment that we believe in and stand by. Omar's question, are deferred prosecutions being treated in the same manner? It's a really good question, Omar. I think, we have to have some conversation with the judges around if we need to make any adjustments to this approach for deferred prosecutions. As of right now, deferred prosecution clients would be treated in terms of non-compliance response, the same as a traditional impaired driving case.
Okay, I don't see any other questions, and we're a few minutes over our time. So I think we can wrap up if there are no further questions.
Well, we just really want to thank you all for being present for our webinar and taking the time to learn a little bit more about what we are doing in the world of probation evolution and how we hope to better serve the clients that come through the doors of Seattle Municipal Court.